Good evening, everyone, and welcome to another in the series of CLE offerings that are made by the New York Law School's ADR Skills program. We're very fortunate tonight to have two experts in the field of mindfulness who will be speaking to us about the importance of that discipline in those of us who practice stressful areas of the law. And they're joined by three younger attorneys who have also, I hope you will agree, important things to add to our conversation. Before I start, I do want to let you know that the April program, which will be the final program in our CLE offering for the spring term, is one that we have a great deal of enthusiasm about. It's the Cutting Edge in Commercial Arbitration program that Jeff Zano of the American Arbitration Association moderates every year. We always have a bunch of folks who show up every year, and it's a good deal of fun, and I encourage you to set aside the date. It's the 22nd of April. We tried to do that during COVID online, but we realized that so many people just enjoy getting together for the Cutting Edge program that we'll be having it here at the school in person at the event center. Those of you who can't make it, yes, we'll certainly live stream it and we'll certainly record it and post it. But I encourage you to take the #1 line down to Tribeca and join us on the 22nd of April for our Cutting Edge in Commercial Arbitration program. Obviously, everybody will get a notice about it. Well, as I say, we're very lucky to have Lynn and Erin Gleason Alvarez with us tonight. And so what I'm going to do is shut up and let Lynn introduce everyone, and I hope everyone enjoys themselves. Lynn?
Yes, hello everyone. Good evening. It's my pleasure to be here with you tonight. This is a topic that is near and dear to my heart. My professional background, I currently serve as the Dean for Advocacy and Co-Curricular Programs at New York Law School, and I'm a professor here as well. I began in criminal practice as an ADA in New York, in the Bronx, went into civil practice, litigation, and had my third career in teaching. So I feel very, very fortunate. Gratitude for the law degree that is the gift, as some say, that keeps giving. How I got into mindfulness, I was always a yoga practitioner, or for a long time, a yoga practitioner. I would go to conferences where law professors talked about using mindfulness to enhance lawyering skills. And I was very intrigued, and I did a lot of reading about it. And during the pandemic, I deepened my yoga practice, and I proposed a course called Mindful Lawyering, which I've now been teaching here since 2022. I'm also on a path through Brown University to become a mindfulness-based stress reduction teacher. So anyway, that's a little bit about how I got into it. And I found that mindfulness has really been a gift for me personally. I was going through some personal challenges in 2019 and beyond. So personally, it's been a gift, but professionally, it's enhanced my teaching. And I think it's really important for lawyers to cultivate many of the qualities that are dominating in mindfulness. So I'm going to turn it over to my co-presenter, Erin Gleason, and then I'll introduce, we have with us today 2 graduating students and 1 new attorney. So Erin.
Thank you so much, Lynn, and thanks to all of you for coming tonight. And it's nice to see a whole bunch of familiar faces in the crowd. So just by way of background, I started out as a litigator And then that didn't really compute in my brain. So I went back to school. I got my LLM at the Strauss Institute, focused on dispute resolution, and then I went in-house after that. I was in-house for most of my career. And then maybe about 8 years ago, I started my own mediation and arbitration practice. And my focus there is in helping people to resolve commercial disputes in employment and in entertainment mostly. And then a couple of years ago, I got a call to start teaching, which had always been on my bucket list, but I didn't think that I would get there for a few more years. But the opportunity arose, and I was lucky that it came through, because it has turned out to be a really one of those experiences that just has brought me so much joy. So I teach the mediation practicum and the mediation advocacy clinics at Pace Law School. And then I also teach a representation in mediation class at St. John's. And it really is, it's a lot of fun for me. I was not always having fun in my career, and that's kind of how I found mindfulness. So I definitely was one of those attorneys who, heard about mindfulness initially, and I tried it out. And I remember the first meeting that I went to, at the beginning of the session, they kind of told us what it was, and they said, okay, we're all going to stand up and hold hands now. And I just left. This was not, my cup of tea, and I did not think that, I needed to see what was going to happen next after that. So I went for a few more years in developing my career, and as I did, it sort of became more and more stressful. And all of this culminated about 10 years ago, when I got really pretty sick. Not related to necessarily the stress of work, but definitely it was one of those moments where I had to kind of pause everything and figure out what was going on. And so in that moment, as a new mom and a wife and a mom and a sister and everything else, I realized that most of my time I was spending kind of chasing things, and whether that was deadlines or work or, I just was running so much of the time, and there was very little opportunity for me to kind of sit back and take a breath and enjoy my life. And so at that moment, it just became really clear to me that there had to be something else. I'd always been a student of yoga, but the mindfulness and the meditation didn't come until it needed to, until I really needed to find a way to calm myself down and to focus better. And so I started, as any good lawyer would, research around, what does meditation really do for you, and what is this mindfulness thing, and does it actually make a difference? Should I really put the effort in? And what I learned was that it does. And for me, in a really personal way, mindfulness has changed my perspective and the way I approach, my personal and my professional life pretty dramatically. But it's also sort of just opened up this new world for me, which has been great. And so I look forward to exploring all of this with all of you today.
So at this time, I want to introduce, we have 3 more participants. Jordan Lazarian. Jordan is a first-year associate at Weill Gottschall. She's a graduate of New York Law School, and was a student in mindful lawyering. I'm delighted to have her here today. She also organized a program on mindfulness at Weill, which I participated in. So it's really wonderful to see new lawyers taking some of these practices and bringing them into the workplace. So hello, Jordan. Okay. And we have Sarah Sexton. She's graduating. She's a 3rd-year law student. She is the president of our, correct me if I get it wrong, Family and Matrimonial Law Society, an editor in the Family Law Quarterly. and she'll be joining the Bronx DA's office next year. And Sarah and our other participant, student participant, Thomas Urcioli. Okay. They were both in my mindful lawyering class last fall. And Thomas also is a 3L. He will be going into litigation. So we have two of our participants are going into litigation. Jordan, you're in corporate restructuring, is that right? Yeah. Thomas will be joining the law firm of Harris, Keenan, and Goldfarb. I'm just delighted. I want to thank the three of you for joining us. And I'm looking forward to our conversation today. Should we start, Erin, with maybe a little talk about what mindfulness is to each of us?
Yeah, I'll let you start it off.
Yeah, so the definition, which maybe you've heard this, John Kabat-Zinn, who in the US is in some areas considered the founding father of mindfulness. It's an awareness that arises from being present in the moment, on purpose, non-judgmentally. And when you break that down, those are qualities that really do enhance lawyering skills, right? Present attention focus, to be in the moment in that negotiation, conversations with client, and trying not to allow habit loops inform us when we go into different lawyer settings where we're working with other lawyers, working with clients. So mindfulness for me, yes, oh, wonderful. I see in the chat. Thank you. Yes, mindfulness for me, and I've been on, the journey of studying it. As I get deeper into it, developing a spaciousness between a stimuli, so putting it in a legal setting, if something's not going well, for example, in a negotiation or in the courtroom, developing a spaciousness between that stimuli and your reaction. So it allows you really to tap into being fully human and non-judgmental. So that's a little bit about what it means to me. And it really has changed. I was a busy, anxious lawyer back in the day. And, academia is wonderful, but it does have some stressors. So mindfulness, it's really, I think, Jordan, I heard you describe it as a way of being once. Can you expand on that?
Yeah, I think that it's like oftentimes, at least when I first started to look into mindfulness, I thought, what really is the difference between like mindfulness and meditation, for example? And I think meditation is like something that you choose to do. Whereas in my mind, mindfulness is more of just a state of being. It is something that you choose to pursue. But for me, it's just, pops up, at random points throughout the day. And that's why I think it is a way of being, and it's a way of life. Eventually, I think it just becomes a part of like your subconscious actions and the way that you perceive things.
Yeah, thank you for that. And meditation is a form of mindfulness, but it's only one of the many different forms: journaling, mindful walking, yoga, any, activity, and it can be formal practice or informal practice that allows you to be fully present in the moment and experiencing, whatever is happening at that moment in a full way. Erin, I'll turn it over to you now. Yeah.
Yeah, thanks, Lynn. And I think that that's a really great point, because when we hear about mindfulness and meditation, if it's not something that you're accustomed to, it can sound kind of intimidating and new and sort of strange. And so I think that the point of mindfulness and the importance of it is it's a really personal thing. And it does not have to be, sitting on a meditation cushion for an hour and having no thoughts going through your head. And if your nose itches, you can't itch it. you know, that's not it, right? It can be listening to music, it can be reading a book, it can be, you know, as you say, going for a walk, going for a run. At the end of the day, it's finding things that are meaningful for you, that give you a chance to clear your head, right? And I think most of us, and probably all of us, need that. And when you look at the impact that this has on people, and we'll talk about it, you know, in the legal context in a second, but you know, there are numerous studies that demonstrate this is good not only for your mental health, it's good for your physical health, it's good for your blood pressure, it's good for your brain. It gives you the space to sort of make better decisions. So, you know, when we are thinking of things in a dispute resolution system, or in those sort of contexts, it's very easy to be reactive, right? There's a lot of trigger points that are inserted into those types of conversations. And I would argue that, you know, responding, and it sounds a little bit of semantics, but it's not, you know, responding is different from reacting. Reacting is where you let someone else sort of drive the conversation. Responding is when you can take a step back and be a little bit more thoughtful in the way that you're interacting with somebody. And mindfulness gives you, you know, that little break to be able to do that in a way that is more in keeping with what you probably want to deliver as the message, right? Instead of doing something that's reactive that maybe you're going to have to retract, you know, further on down the road. So, you know, however you choose to do it, it's like many of the things that we talk about in dispute resolution world. You know, there are no hard and fast rules for this. It's really something that, you know, needs a bit of consistency, to Jordan's point, in order for it to really work. So you think about, you know, what are the opportunities that I have over the course of the day to take little breaks, and to make sure that I am sort of taking care of myself, and I'm not getting caught up in the, you know, the cycle of work and the stress that often comes with that. And I think that kind of takes us to our next point, Lynn, which is, you know, the way that all of this is really important for lawyers in particular.
Yes, yeah. So some of the foundational principles of mindfulness, I think I mentioned the attitude of non-judgment, which, you know, in law practice, we come with expertise to different situations and cases, but to try to keep, you know, an open mind and acknowledge when we are going into a situation with judgment during the negotiation, and try and just observe that, and then have a curiosity. That's another tenet, having this curiosity in a beginner's mind. So these are mindfulness principles, but it really resonated with me, and there's a lot of literature on it, that it applies with equal force to lawyering skills, including interviewing, counseling, negotiating. So, you know, lawyers, to do a good job, you all know, you're all experienced practitioners, you really have to be present in the moment, focusing, right? If the client is speaking to you, or your adversary during a negotiation, you have to be in that moment. Whatever else is happening, you know, in life, and life is going to happen. You know, mindfulness is not a cure-all. And we're often reminded of that. It's not like a magic wand that is going to just infuse, you know, it does infuse joy. I will say that it infuses joy, but life is going to continue to happen. And that's something in the mindfulness arena. They mention, you know, things, good things and negative things are going to continue to come at us. The analogy, you might have seen this, you know, you can't stop the waves, but you can learn to surf. That's a John Kabat-Zinn, I believe, quote. So you all know that well, I'm sure. In law practice, you can't stop those waves. Things are going to be coming at you. Same in life. But being present, a way of being where you can maybe have some calm and equanimity, can help you, as you're navigating through different lawyering scenarios. In addition, as Erin mentioned, there are a lot of studies about the benefits, attention regulation, emotional or self-awareness, right? Self-awareness, which can be extremely important in negotiating. Also physical benefits. There have been studies on that as well. So, I think my course is focused on mindfulness as a tool to enhance lawyering, but also to enhance attorney well-being. So it's kind of a two-prong inquiry in my course. I should mention there is a Professor Leonard Riskin who's written quite a bit on mindfulness in dispute resolution. And just an interesting factoid, I believe Harvard was a while back, had a program on negotiation and wellness and mindfulness. So that kind of was one of the earlier acknowledgments that, this is not, it can be sitting on the floor on a cushion, but it certainly doesn't have to be, right? And there are tools that can be really helpful in law practice. I'm just wondering, Sarah or Thomas, do you have anything you might want to add before, and Jordan, before we bounce it back to Erin?
I think one of the things Professor Sue was just talking about as it pertains to active listening was something that we discussed in our class at great length. And then after the class I took in the fall, I took another class with Professor Sue in the spring, which was the art of cross-examination. And one of the things that was stressed in that class was active listening as you're cross-examining the witness and making sure that as you're active listening, you might be adjusting the questions that you were maybe had come in with initially planned to ask, but as the conversation maybe took a direction that you hadn't anticipated, you were present in that moment and adjusting your questions based on that. And that was something that I really, from the mindfulness classes where I learned that skill and then was able to apply it sort of in that classroom setting during the art of cross-examination.
Thank you.
And similarly, the quote about surfing, I always thought about how you discussed in class the ripple wave effect and how sometimes, a certain action or something that occurs to you, it's going to have a ripple effect. And it's sort of learning how to deal with each of those ripples at a different level.
Yeah, really important. As lawyers, you have a lot of ripples, a lot of different cases. The client is in the center of the pool, so to speak, but the ripples are affecting you. So mindfulness can be a tool, as Sarah was mentioning, to help you navigate with that.
Yeah, the thing that keeps coming to mind for me and probably for many of the folks who are mediators in the room is that, all of this plays out in mediations all of the time, right? Because it's a more private space. It doesn't have all of the sort of pomp and circumstance of a courtroom or even in an arbitration. And so participants in those conversations, can be a bit more vulnerable, and emotion is often an important part of all of these discussions that happen in the caucuses or even in the joint session in a mediation. And so, the danger with this often becomes that when the emotions come out, you don't want them to start driving the bus. It's not to say that it's right. People shouldn't be feeling emotions and they shouldn't be, letting them out in these settings. I think that they should. It's just being thoughtful about how you are leveraging emotions, how you are acknowledging them and sort of processing them in real time when you're in an important discussion and you need to make potentially important decisions. So before I continue, I just wanted to put a link in the chat here. And we'll talk more later on in the program about various resources for lawyers in the New York area. But before I get into the, sort of statistics around, why this is so important to us, if you need help, right? If you're an attorney in the New York area and who needs support at this time, the City Bar has a confidential hotline that's available 24/7. I just put the link in the chat, and that's always available to people. And the stress and depression and substance abuse that exists within our profession is pretty real, and it has not gotten better since the pandemic. So, over the course of the past 5 years, it's been, kind of level. And one would think that, now we can sort of go out and we don't have those fears that were following us around in 2020, which were, significant. But if you look at the ALM report from last year, where they're examining the mental health of lawyers, it was 49% report that mental health and substance abuse are at crisis levels. 70% of lawyers indicated that they are exhausted. 79% feel that their work environment contributes to all of these issues. And 77% of them reported that the profession had a negative impact on their mental health and their well-being. So, I think we have to have this conversation, because if we don't, what happens in the next 5 years, and there has to be significant attention to this issue, and sort of the ability for folks to talk about it in the open like we are, because a lot of the time there is this sort of shame and embarrassment around, accepting the fact that we need help. Peter, I see you're here.
Before we go on in this pretty fascinating and pointed discussion, my job is to make sure that everyone who earns their continuing legal education credit gets their continuing legal education credit. I'll be giving out 3 code words during this presentation, and everyone has received a link to a form that, when we're finished, I'd ask you please to put the code words in the form and return them to Rose White, and we'll make sure that you receive your CLE credits. So the first code to take note of is John, Jon. The first code word is John. With that, Erin and Lynn, off you go.
Okay, yeah. So following up on the ALM report, the New York State Bar Association in 2021, they issued a report on wellness. It was a well-being task force, and the report was called From Striving Alone to Thriving Together. And I think Peter will be sharing the link to that report with you. And it's very interesting. The working group studied lawyers, judges, law students, a variety of people who are working, in legal settings. And, again, echoing what Erin shared, this is a stressful profession, right? It's a rewarding profession, but it's a high pressure profession. The work, doesn't always end at the end of the day, as you all know, right? There are a lot of human interactions that are wonderful, but can also be kind of challenging, right, at times. So anyway, it was very interesting. This was in 2021. It's a lengthy report, but it's an easy read, so I recommend it. And then born out of that report, there now is the New York Bar Association, State Bar Association has an attorney well-being program and a committee. So I'm on the committee for attorney well-being, and there are different subcommittees. But, echoing the points that were just made, there was an acknowledgement that there are problems, right? There is stress, there is vicarious trauma. Some attorneys, unfortunately, turn to or have addictive behaviors as a coping mechanism. So it's important, and I think it's being acknowledged more and more, that we need to talk about these issues and, normalize, we talk about this in my classes, normalize, and this I think holds true as well with practitioners, the challenges, right, that there are in practice. There are a lot of challenges. The business demands, the client demands, the not having enough time for maybe family. So all of that, the stress of maybe different cases. So it was really heartening in 2021 to see the New York State Bar Association, issue this report, and then they backed it up with this attorney well-being program. So you can find that online, and there are different things you can participate in. One of the big, components, or a component, is mindfulness. So yeah, not to paint a grim picture, but this is it's a helping profession. I like to say that it is a helping profession, where we're taking on other people's problems. Sometimes it's in a good, setting, other times not, but it's a helping profession, and helping professions do have high levels of stress.
Yeah, for sure. And, for me, I guess I see that the most when we're sitting around the negotiation table. And so the problem there is, and I think where mindfulness has a real opportunity to make change for people, is that, when you were sitting in a conversation with people who, perhaps you wouldn't choose to otherwise spend your time with, you can get surrounded by your own thoughts and your feelings about the scenario that you are living out. And when that happens, right? So when the thoughts and the emotions start taking over, you're missing the finer details about what's going on around you. And this potentially, puts you at a disadvantage, from a strategic perspective. We all find ourselves in negotiations all the time, every day, about minuscule things, right? So, we're negotiating over things with our, coworkers, or at home, are we going to have pizza tonight, or pasta, or whatever? And those things don't really hit the radar, right? These aren't negotiations that feel like they're of much consequence. It's when the bigger stuff comes in, and we start to sort of put more pressure on ourselves and on our performance and on the output of that proceeding, that it's hard to stay focused, and where it becomes imperative to have a system in place to help you do that, before you get there, right? So you can't really get to a negotiation and say, okay, I guess I'm going to do the mindfulness thing now, right? And I'll start doing it today. I mean, you can try to do that, but it's easier if on a day-to-day basis you have some sort of a practice that you can rely on when you notice sort of the heat going up for yourself, and sort of the nerves rising, or whatever it is, you're angry or frustrated, all of those things that are completely normal in these conversations, but that can potentially put them on a path that you do not want to be on, right?
Yeah, and I see there's several comments, I'm trying to keep up with them, but one from Professor Matthews, which I'll read from my lens. Mindfulness is also situational awareness, understanding microaggressions and implicit bias, and embracing cultural humility. So, that's a wonderful point, that mindfulness can help, right? This attitude of non-judgment when you're, in a situation, and, the communication is not what it should be, recognizing that, but it can help us resist, right? Going into kind of a habit loop that is not positive. So I just wanted to thank you all for your comments. We're trying to keep up with them. But that is a very big piece of it, that in mindfulness generally, mindfulness training, they talk about that quite a bit. And I think it can be quite helpful also in lawyering, because lawyering is a cross-cultural practice, right? And there are going to be differences, and to try and have this lens where you're self-aware, situationally aware, and treat each others with this humility and respect.
Yeah, I think that, it also brings up the great point about the cultivation of empathy for the people that you work with. And, the thing that I tell my students is, somebody can show up, to work with you, and maybe they're, angry or overly aggressive, or something that just doesn't sit right with you, right? But, at the end of the day, we have no idea what this person's life is like. You don't know if something tragic has happened to them the day before. You have no view into what their life experience is or why they're showing up in the moment the way they are. The only thing you have control over is the manner in which you are able to respond to them, and potentially, sort of set a different tone for the conversation. So I think that there's a lot of room in this type of work for understanding not only that people are coming from different cultural backgrounds, but from different life experiences, and accepting that we can't change that for somebody else. You can only work with sort of what you have, and what you have is your own self-possession and your ability to recognize that, maybe somebody is just having a bad day, and I'll give them a little space, and then I can sort of model the way that I think we should interact on a going forward basis, and try that instead of engaging in a combative way.
Well, the empathy is so critical in mindfulness practice. And you might be wondering, mindfulness, it can be meditation, breathing exercises, walking meditations, just really being present in the moment, taking a moment, right? I think Erin mentioned this, taking a moment if it's a stressful situation. It can be mindful movement if that's something available to you. It can be journaling, which is a good, practice. I think in general, and especially in lawyering situations after a case, right? Negotiation, or other, to do a little journaling about what, was positive, maybe what could have been improved upon. So mindfulness, it can be an informal practice, it can be a formal practice. Several comments have been made that consistency, right? In one of the readings I assign, they talk about mindfulness. I don't remember the author, but a superpower for lawyers, right? That with the various other skills, and reflecting on some of these qualities that we're describing, and some of these practices can be helpful in strengthening your ability to show up in a meaningful, authentic way, non-judgmental way, and also help you, right? To help you, because it's not sustainable if we as lawyers are stressed out all the time. Do any of our new lawyer or lawyers to be have anything you'd like to share at this point?
One thing that comes to mind is I think that I often, just like probably many of you, have this tendency to want to be perfect and to want interactions to be perfect and my assignments to be perfect. And that's just not a reality. So for a long time, I focused a lot on like past interactions or past assignments, and I would worry a lot about upcoming things. And I think that a big lesson I've learned from mindfulness is that it's important to do your best to not dwell and to not worry about the future, but rather focus on the present moment and do things like we were talking about, active listening, because that does make a big difference in your, I think, self-confidence as well as your performance and your efficiency. And that if you do revert to worrying about the past or worrying about the future, that's okay. It's important to acknowledge the feelings that you're having, and to, not judge your thoughts. I think that's something that I'm still learning, and I think that we're all on a journey of growth forever. But this conversation just made me think of that, and that's like one of the biggest things I've taken away from my mindfulness journey, and it's helped me a lot in everyday interactions with my colleagues, with supervisors, and beyond.
Erin, should we move a little bit more now into dispute resolution, some of the specifics with respect to that?
And the way I think about it is sort of at the different, and for our purposes, we'll do kind of truncated phases of the negotiation or mediation process. That's usually where I talk about these things. So that's the space that is usually most comfortable for me. But I think it certainly applies in arbitration, or when you're preparing for court, or even for a deposition, because it all starts with plan, right? So before you actually get to the event, there has to be a certain amount of time spent in preparations and sort of reflection. The couple points here are that you can't really achieve success in a negotiation, for example, where the entire process is dependent upon your ability to communicate with other people and to interact with them and trust them to a certain extent. So if your preparations are completely centered on yourself, you're not taking the bigger picture into consideration and sort of reflecting on all of the different factors that are going to play out and that are important. And I think that for folks who if it's a stressful negotiation that's coming up, if this is something that makes you nervous, for example, one of the most fascinating lessons that I think I've learned comes from sports. And so there are all of these studies about how athletes get ready for, the US Open, or for the NBA finals, or, just a regular everyday golf match. And so the studies, according to my memory anyway, indicate that, maybe 30 to 40% of these, greatest of all time athletes, they spend that time in physical training. And then the 60 to 70% of their time is spent in mental training their mind, right? And so Novak Djokovic is sort of the perfect example. So when he was a little kid, he could already see himself, winning the Roland Garros, or, any of the other, big tournaments, and had this very clear vision of his success. And there have been studies on entrepreneurs in this vein as well. So those individuals who were starting companies and had a really clear vision of what that company was going to do and how it was going to be successful and what all of that looked like in the future, those are the people who succeeded. So there's no reason that you can't do this when you're preparing for a negotiation, and I think that you should. And so the visualization, for us in this context is, can I see myself, in that conversation, and I'm clear on what my goals are, and I know how to come across in a way that is, whatever is important to you, that is credible, that is collaborative, whatever it is. And I'm able to sort of get my points across so that I can also envision what life looks like after this event. And when I have realized those things that I have, hoped to achieve. So I think that it's so interesting to me to learn about this, how this plays out in other areas, and how it relates to our work, I think, very clearly. And there's lots of, sort of information out there about visualization, meditation practices, and how you can use that to sort of calm yourself down and sort of get to a place where, you hope to be in the very near future.
Yeah, following up on that, that's a great point. And there's a book, The Inner Game of Tennis, which is really wonderful and talks a bit about the mental game behind it. I recently discovered on my sleuthing for mindfulness information that the Navy SEALs, that's a high stress, right, situation. They use what's called box breathing, a four count of 4 4 4. And they're actually trained in that when they're encountering and breathing practices. It doesn't have to be a formal, but there are many different meditations, breathing practices. It can just be sitting quietly as well and doing open awareness to kind of calm yourself and not, perseverate about the future or live in the past. Try to bring yourself back to the moment when you're going to begin your negotiation. But there is credibility for all of this because it's not limited to it's athletes, it's Navy SEALs, it's also a basketball player. He would meditate. I forget who it was, but I shared that with my class recently. So, it's something that maybe we meaning the legal profession, we haven't shown the spotlight on it as much as we should. When I was a new attorney, the mentality was more, you're going to just get through this, and fortunately, I always had wonderful colleagues, so it was a supportive environment in the different areas I worked in. But I think the mentality was, kind of grin and bear it. And that might be true for some of you on the call as well, but I think our newer attorneys and attorneys to be are starting, to enter in a field where, we're realizing it's really not okay for people to show up not okay, right? For a client or for a negotiation, you have to have the tools to to be there fully, to be, in a state where you're able to be an effective negotiator and an advocate.
Yeah, I think that it's such a great point, and really I think often missed. I wanted to get back to one of the points that I think a couple of your students have just made over the course of the past hour or so, Lynn, which is active listening and sort of the value and the importance of active listening. So there was a study that was conducted by Accenture, and it involved around 3,600 people, and they were all, 30 different countries, I think it was, and in professional roles, right? So, work for various different corporations. And it was to study, their active listening ability. And so these individuals were surveyed, and they wanted to know how many of the people considered themselves to be good listeners, and 96% of the respondents said that 100% they're good listeners, right? So 96% of respondents. So then we contrast this with a completely different study, different people, but it was conducted by the University of Minnesota, where people who identified themselves as good listeners participated in this sort of an experiment. And here they were asked to sit through a 10-minute verbal presentation, and then later on they had to describe the content back to the study people. And so the participants, 75% of the people who listened to this could not recall the subject matter at all 48 hours after they had listened in on this, right? And so these are the people who are reporting themselves as, I'm a good listener, you can put me up to the test. And so, we're not, it's really hard to listen to people. And I think it's harder for us as lawyers because we're taught not to listen to people. When someone is communicating with you in a professional setting, what are you supposed to do? Well, you have to analyze what's wrong with all the things that they're saying, right? You have to think about what your comeback is going to be. maybe you're reacting to the information that's being shared with you. Maybe there's something new in there, maybe there's a surprise, maybe it's something you don't like. All of this is happening in your mind when you're just supposed to be very simply listening to another human talking to you. Go ahead, Peter.
Well, I want to share the second code, but first I want to share an observation that a Quaker friend of mine made. We were talking about dispute resolution in Quaker meetings. And she said that you're not listening when what you're doing is trying to figure out how to make the person feel better. Anyway, the second code word is Kabat, K-A-B-A-T, Kabat, K-A-B-A-T. Thanks. Off you guys go.
I think I know where this is going with the codes. Yeah, the active listening, it, in all areas of lawyering and actually life, really showing up and giving that person the gift, right? The gift of listening. And it can, really be of great value when you're in a negotiating setting. And obviously we're thinking about our client's position and things like that. But, listening, because maybe there's an opportunity for creating, some type of resolution that's going to have benefit to both sides instead of value, claiming, going in, as they say, with the value claiming attitude, more of a value creation. And I think that the active listening and trying, although we come in with the notions because we're human, right? We're human and we have a world view, and that's how we make sense of the world, but trying to recognize that and say, hey, self, I'm coming in with these preconceived notions, I'm recognizing it, I'm going to put them aside for a minute and just listen. And that's a mindfulness practice that could, I believe, be helpful in a situation where you're trying to create a solution that might be beneficial and more palatable to everyone. Whereas, if you're butting heads, you may not come to any agreement, and nobody, would be particularly happy in that situation. So, yeah, the active listening, it came up, I think Thomas alluded to that. I know this program's on negotiation, but with the art of cross-examination, you have your questions, and they could apply as well in negotiation. You have your points that you want to bring out, but in the cross-examination setting, you have areas that you want to inquire about. And certainly that's something that you should be focused on. However, if the witness says to you something unanticipated and it could be helpful, you don't want to move on to your next point, right? And lose that opportunity. That could be a big lost opportunity. So it was very interesting. My co-teacher in that course was really talking about he wasn't using this terminology, but about being mindfully present in the courtroom. And, the negotiating table. And I think that's where we are in our outline, right? We're at the negotiating table now.
Yeah.
It's very important in the negotiating table, moving out of the courtroom to the negotiating table, right?
Yeah. And, I think that, like I said before, I think it's too hard to start the practice of this, in the actual, whatever legal proceeding you are in. So if this is hard for you, and it continues to be difficult for me because I have, 50 tabs, right, open in my brain at most times, and I have to figure out, I just focus on the one, right? Even though the 49 others are really interesting. But so, you pick small ways to start working on this. And I think that's, active listening in baby steps. When you're watching a movie with your friends or your family, actually watching the movie and not, scrolling at the same time and looking at Instagram or TikTok or whatever, and being able to have an actual conversation about the details of what, you are observing, right? Instead of being sidetracked by all of this other craziness that goes on the phone. And then the same thing, when you get home at the end of the day and, or you go out with your friends or whatever it is, maintaining eye contact with people when you're having a discussion with them, and particularly the people who mean something to you, right? Because that makes those conversations so much more meaningful and engaging, and it demonstrates to the people who you care about that you really care, as opposed to, I got my phone and I'm like checking my email or updating my calendar, whatever it is. It's so easy to fall into those habits. And so just these little things, little ways to kind of practice, I think, active listening on a daily basis actually go a long way, and give you that sort of focus, so that when you were in the high pressure situation, okay, I'm not focusing right now. I need to put my attention back on this other person, because otherwise, you really, I think, are putting yourself at a disadvantage in a negotiation setting. I think you're putting yourself at a disadvantage on the personal side too, if you're not signaling to the people around you that you're actually listening to them, and being able to sort of respect whatever time they are giving you. But on the professional side, you want to make sure that you're really tuned in those moments, because otherwise, you're missing opportunities, you're missing information, you're missing the cues that are, otherwise being relayed to you, when you're cycling in your brain.
Yeah, so important about this, attitude of being fully present, fully aware. Emotional regulation, I think we touched on that, but mindfulness, and I'm sure all of the attorneys on this call and the professor have, been in situations where someone has spoke to you in a way that's not mindful, right? It might be, a little harsh or unkind, or, I'm talking about in a legal setting now. But having, these tools, and we're human, right? And so we might be annoyed or angry or want to respond in kind. But when you strengthen the mindfulness muscles, so to speak, when you strengthen that, it creates, this ability, this spaciousness to be less reactive. Not that you won't feel the emotions if someone is rude to you in a negotiation, or, makes some kind of outlandish, request. Not that you won't feel the emotion like, oh, what are they thinking, or that's insulting, or, but that you kind of have developed a way of being where you're a little less reactive, and you sit with it, like, okay, you want $20 million? All right, that's not happening, and so it's not coming at it in an aggressive way, but this notion of not that we won't feel emotions. We're human. We're always going to feel emotions and experience emotions, and we shouldn't push it down. But cultivating the ability to maybe be a little less reactive in the moment. So, yeah, Erin, do you have any thoughts on that at the negotiating table?
Yeah, I think that when the pressure goes up, people start moving faster, right? So you're talking faster, everything is going fast, and we're New Yorkers, so we are already fast, right? So then it gets to like lightning speed. You have to purposefully know to slow yourself down. I think that in those moments where it starts to get heated and people are talking quickly, just reminding yourself that you don't have to follow that cadence. You can set your own tone and stay moderated so that you can concentrate. And the other thing I think is, and this gets to the getting to yes and getting past no books, and I can never remember which one this is from, but going to the balcony. So I think that it's important to remember that every conversation does not have to be completely filled with words. You can pause right? And maybe that's when you're at the table, and just decide that you need to take a moment of silence to digest whatever has been said, to give yourself some time to process so that you can respond and not react to whatever this, other person is saying to you. That's a perfectly fine and accepted, negotiation tool that that I think is really effective. First, because it builds you a cushion. If you're feeling kind of activated in the conversation, gives you a minute to sort of process and bring yourself back. But the other thing is, most people are pretty uncomfortable with silence. And so in that, small moment of time where you have decided not to immediately react, the likelihood is that the other person is going to start talking again. And because we just are so uncomfortable with that silence, right? And it's always universally fascinating, the information that comes out afterwards, right? Because now somebody is talking because they feel like they have to talk, and it's either a nervous reaction or it's sort of, I feel like I have to continue explaining myself. So you just let that go, right? And that can be a real gift in these conversations. So instead of feeling like you have to, start speaking the minute that somebody else does, just giving it a little bit of time and just letting it process. And then the last thing I'll say here on the, being at the table is you have to know yourself. You got to know what your trigger points are. What are the things that are potentially going to set you off in a conversation? And how are you going to acknowledge that if it comes up? For me, look, I've been the only woman in the room for 25 years, 95% of the time. I hate it when people talk over me. It drives me insane. And to me, in the minute that it happens, it is a signal of disrespect. And it makes me crazy. But that's not always the intent of the person who is doing it, right? It could be cultural. It could be that this other person is equally upset. They need to sort of have their voice heard. It could just be their way of talking. It has absolutely nothing to do with me, right? So I know how to, or I have to, encourage myself to sort of remember that when I'm in it, I know what my own trigger points are, and I have to manage them, because it's more important for me to be a full participant in this conversation than to be focused on this other stuff. Does that make sense?
Yeah, that's and I think that's so important and related to that. And I think, lawyers are trained this way, and we talk about it in law school, right? To kind of always be thinking of a narrative. Oh, people, this is the event. And then we're creating in our minds, right, a narrative. Well, they did this or didn't do this for these reasons. And sometimes it's good to, there's a writing by two law professors, Jean Co-Peters and Susan Bryan, The 5 Habits for Cross-Cultural Lawyering. I think that's the title. But they talk about parallel universes, thinking about trying to resist. And that's kind of how I think we're trained in a way to be thinking about, why did they do this? And what's the alternative argument? But to step back and think about parallel universes, what are the possibilities that, might be instigating or promoting this kind of behavior. So I think mindfulness can help us recognize when we're going to creating the narrative, right? And give us the ability to maybe take a pause, and maybe we're right? We could very well be right, that because you're experienced attorneys, you know a lot about human nature, you know a lot about the law, but we could be wrong, and sometimes we are wrong. So when we're kind of going into those habit loops of thinking, to kind of take a pause and think about, a possible parallel universes. That's a term from this piece that I mentioned. Just, also with, any lawyering task, the preparation, the setting the intention, when you're going into the negotiation, setting your intentions, your, the options, the goals, all of that, in the planning phase, there's a lot of intentionality, underlying mindfulness, although it's being present in the moment. When you're planning, right, you can be present in the moment and you're looking at the legal context of the negotiation, right? What are the laws, the shadow of the law? What are the client's goals? What are the options? What is the BATNA, the best alternative to a negotiated agreement? What's my client's BATNA? What's the other side's BATNA? So you're doing all that, planning and preparation. And mindfulness, I think, can help you be focused, focus on that and be present, and then feel, a sense of control when you go into the negotiation, that you're well prepared. It may not unfold the way you want it to unfold, but you feel, confident that the planning has been fruitful. Boy, we are really like talking a lot. I'm talking a lot. I'm looking at our schedule. Where should we go to next, Erin?
Very quickly, let me just round out the negotiation process, because the last part is, what do you do afterwards? So regardless of whether the case settles or it doesn't, there needs to be some sort of a reflection, I think, at the conclusion of the process, so that you can learn, right? And so I think that the careful balance in this exercise is, as we've said throughout the program, proceeding without judgment, right? So this is not intended as an exercise of beating yourself up for missed opportunities or saying the wrong thing at the wrong time. It's really conducting a balanced assessment of sort of what felt right for you, what didn't, and seeing it as an opportunity at the conclusion to sort of learn a little bit more about yourself and how you can continue to hone your skills with each negotiation, which is something that everybody has to do.
Yeah, self-reflection is so important, I think, in life and in law practice. The attorneys to be and the new attorney, they were engaging in some self-reflection. And I think for the most part, I found with my classes, initially people may not like doing that, self-reflection, it's another kind of make work thing, but it actually gives you the space to, in a professional setting, to reflect on how something went and maybe learn more about yourself. I know we're getting short on time, but any Sarah, Thomas, or Jordan, anything on self-reflection? Any takeaways on that?
Yeah, at first I was sort of dreading it as an activity. As you said, it just felt like, oh, it's just another homework assignment and I have to sit here and now I have to think about something. But I actually really enjoyed it a lot and I felt it was a very useful technique. And, I am involved in clubs in school and those can be stressful working with other people. And it was just an outlet. It was a way to, just have an overview of what I do and how I react to it. And then I could watch myself grow as I was reading these journals. And then at the end of our class, we had a paper that we had to write on our growth. So I sort of used these journal entries when writing my paper, and it was really cool to see. So it's a technique I'm hoping to implement when I'm working.
Oh, yeah, thank you for that.
I had a similar experience with it. I think I was, sort of at first hadn't had much experience with it, so it was tough initially. And then once I really, started doing it weekly, it felt like a great outlet to sort of lay out, the things you had done, what had went well and what had went poorly. And then at the end of the semester, having to go back and review them, I think they're such a great tool going forward, particularly when times went well and maybe things aren't going as well at the moment. What were the things I was doing at the times that things were going well? And then vice versa, if I had done something well, if I, looked back and said, these were the things I had done that didn't go as well, and this was the preparation that I had done for those moments, it was a great way to sort of compare and contrast and then use them in the future to try and obviously take advantage of the things that I had done that had worked well, and then try to avoid the things that I had journaled about that hadn't gone as well.
Okay,
You
do we have
know-
another code? And I think I can guess what it is.
If I could interject again, this really is a fascinating topic. One of the cool things when I was a litigator was that you learned so much about so many different, companies or so many aspects of life. And here, it's an even better job because I'm getting to learn all of these aspects of lawyering of which I had been really unaware. I'm very, very grateful to Lynn and Erin for the contributions that they've made, and to our younger colleagues as well. I think it's probably timely to go ahead and give the third code, if that's all right with Lynn and Erin.
I think it starts with a Z. No?
All right. Well, yeah, actually, I'm pulling this right out of my ear, but I'm calling the third code Zinn. Okay, Zinn. The third code will be Zinn, and as I said, everyone should have received a link to a code submission form, so you can put those 3 words in and submit them, and we'll get the credits to you. You guys are great, and I'm so grateful. Oh, well, indeed, all of us are really just so grateful to all 5 of you for sharing your insights in this and your wisdom. It really is a form of wisdom, isn't it? Not just learning. And it was time very well spent. So thank you. Thank you, everybody who came along. And I hope to see you, if not online, I hope to see you in the Event Center at New York Law School on the 22nd of April. That's Earth Day, and it is our annual cutting edge developments in commercial arbitration. Thank you all.
Well, thank you for organizing this, Professor Phillips and Erin and Sarah, Thomas, Jordan, and all of you, really, to be in community like this, and to get the opportunity to talk about this really was wonderful.
Yeah, thanks everybody. This was it was lovely to have you all here and to participate. I was just looking through the chat now. So thank you for all of your thoughtful remarks, and hopefully we can continue the conversation.
Thanks again.